Welcome to week 4. This is podcast 7, and we're going to be talking about civil liberties. We instinctively distrust government. This is something that goes way back to the Revolution, so it's not a surprise that we wrote our Constitution, and specifically the Bill of Rights, that's the first 10 amendments, with an eye to protect ourselves from government action. These are called civil liberties. Now, as your book points out, there's a distinction between civil liberties and civil rights. We're going to talk about civil rights in the next podcast. But civil liberties is about telling government what it cannot do to individuals, while civil rights is telling government what it must do to protect everybody. For example, that everyone should have equal protection under the law, no matter what the color of your skin is or where you came from. That's the 14th Amendment. Has the Equal Protection Clause, as well as the Due Process Clause, which says that everyone must be treated fairly in the legal system, and you cannot arbitrarily deprive a person of life, liberty, or property. But the tricky part here comes when we try to define the boundaries of this automatic freedom from government action that we've granted ourselves. Courts are often challenged with defining this space. And like most things we've talked about in the class, that's an interpretation that changes a lot over time. So let's look at the First Amendment, which everyone knows is the Free Speech Amendment. But it actually says a lot more than that. It says, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. So all of those things sound pretty straightforward, but the reality is that courts have found the government can restrict you when there are competing interests involved. So these rights aren't completely absolute. For example, you may want to lead a peaceful march down the street because you know you're allowed to assemble wherever you want. But the government also has an interest in keeping the streets orderly, so they can require you to get a permit to do just that. Another example, you can say whatever you want, freedom of speech, but under the slander and libel laws, where if you publish lies about someone and it ends up hurting them in a particular way, you could get sued, and you would not be completely protected under the First Amendment. I will say that courts are very hesitant to put restrictions on any of those civil liberties I just listed. You really have to present something that's in the common good. You have to say that the common good has been harmed in some way, or perhaps an individual's other rights have been harmed, to gain some kind of restriction on those civil liberties. So we're allowed to practice any religion we choose, but in this court case mentioned in your book, Engel v. Vital, decided in 1962, the court ruled that school-sponsored prayer in public schools was unconstitutional because it violated the Establishment Clause of the First Amendment. Because public schools are funded by the government, officially sanctioned or encouraged practice of religion is in danger of suggesting to school kids that public schools endorse a specific religion. So like I said, judges are mostly unwilling to allow any breach of the Establishment Clause. Even, for example, a moment of silence in Alabama schools, this was one law mentioned in your book, was meant for meditation and voluntary prayer, but even that was ruled unconstitutional in 1985 because it was seen as a de facto endorsement of religion. So religion's not the only one. The freedoms of speech and press have been considered so important to democracy that a whole legal doctrine arose called the preferred position doctrine, which means that certain freedoms, like speech and the press, are so important to democracy actually functioning that any law that limits them, that comes from the states, should be presumed unconstitutional, unless the government can show that the law is absolutely necessary. All right, so what about those rights that aren't enumerated or expressed in the Constitution itself? One of those you hear a lot about is the right to privacy. Or if you're a libertarian, maybe you think of it as the right to be left alone. Now, this right doesn't appear anywhere in print in our Constitution. But as you read about in the book, there's many court actions that have come up that have made it so we consider it an implied right and indeed guaranteed right just by the wording in the First, Third, Fourth, Fifth, and Ninth Amendments. And this right to privacy lies at the heart of the abortion debate in this country. It's one of the most politically divisive issues of our time. So it's really important you understand this. Now, using this thinking on where the right to privacy comes from, we have two cases, Griswold v. Connecticut in 1965, and of course the more famous one, Roe v. Wade in 1973, in which the Supreme Court justices held that, and I'm quoting here, the right to privacy is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. So the whole abortion debate rests on that right to privacy. As some of you know, though, since that time, and it's been a long time now, because the courts allowed states to make laws regulating abortion for health and safety reasons, we've seen a lot of state laws that have imposed more restrictive standards on when and during a pregnancy you can have an abortion, or even what kind of doctors can perform an abortion. And that has really made it increasingly difficult in states with more pro-life legislators for women to get access to abortion. So the debate goes on, but if you ever have this debate, I hope you can bring what you know now about the right to privacy into it, rather than it just being a black or white moral issue, because it really is about civil liberties. So privacy is another one of those rights, just like the expressed rights that is constantly open to interpretation. And I think all of you should pay very close attention to this in a time when we've just learned that the government's surveillance of every citizen's communications and internet activity is a lot more extensive than anyone could have ever imagined. This came out, of course, with the Edward Snowden revelations. This is someone who worked for the NSA and then released lots of classified information that has the government, pretty much in chaos at this point. But something to ponder is how far you think, because this is often a personal thing, how far do you think that right to privacy extends for you? Is it something that you think it's important enough to be a deciding factor when you sit down at the polling booth and make a choice for a legislator? In other words, are you going to vote for a legislator who shares the same idea of what right to privacy means? Or is it not that important to you? There's an interesting debate on the death penalty on page 93 of your book. Take a look at that, and as an exercise, try to recast the death penalty issue as a civil liberties issue, rather than just, you might normally think of it as a crime and punishment issue or a moral issue. Sometimes it's tied to religion, the sanctity of life. That's how most people think about it. But it's really a civil liberties issue if you think about it as under the Eighth Amendment, which bans cruel and unusual punishment from the government. This is another thing we wanted to protect ourselves from. And, you have to ask the question, should we get rid of it under that assessment? Is it a cruel and unusual punishment? Is it unconstitutional? Or does it serve a greater need, and we can actually, in this case, go against the Eighth Amendment, or perhaps not consider it a cruel and unusual punishment? It's an interesting topic, and I hope you can apply some of these things you've learned about civil liberties to every issue you come across. Thanks, and I'll see you next time.